You'd like to say
I will. Let me go as quickly as I can. When I saw that Mr. Rabin was on this panel, it eliminated a lot of what I wanted to talk about or felt I might need to talk about. For me, as a practitioner, I practice law in West Tennessee, and this is an issue of due process under the 14th Amendment, 5th Amendment, U.S. Constitution, and Article 1, Section 8 of the Tennessee Constitution. And so, to me, the essential focus should be is due process. In other words, notice and an opportunity to be heard. So, without taking everybody through the forfeiture law in Tennessee, which I think all of you are pretty familiar with, I don't think that's necessary. I thought I would go over three actual experiences I had, and then I'll watch the clock before if there's time, and then talk about how I would change the law, what my recommendations would be to improve it. The first one of these cases I ever had, a young man was stopped on a traffic offense, and he was found in possession of some drugs, and they seized his vehicle. Now, this is in Obion County, Tennessee. His vehicle was owned by his mother, who lived in Houston, Texas. And I called his mother. She had no idea, of course, that he would be driving at 1 o'clock in the morning in Obion County and might have drugs in his car. By the time I got the case, of course, the forfeiture warrant had already been issued. So the case is with the Department of Safety, and I contacted their representative. I wasn't able to talk to an attorney. And I simply asked the question, okay, how are you going to prove that this owner knew or should have known that her son would be driving around at 1 o'clock in the morning in her car with drugs in it? That case, I don't get it how these cases, most of these cases get worked out on the way a rational person would. In other words, how much is it going to cost me to pursue the legal route? How much can I get? If it's a weak case, how much can I just pay and get my property back? It's a practical matter. Another case I had, an owner of a trucking company called me. His 18-wheeler, including the trailer, had been seized. And the facts were that the driver was driving through our town without a seatbelt on. He was pulled over, consented to a search, and the search produced inside a briefcase, the driver's briefcase, in the cab of the truck, a small piece of methamphetamine. They seized the whole truck. Same drill. I tell the lawyer what I would charge to represent him. And again, part of that is because there are these two hearings that was already referenced just earlier by one of the young ladies that testified. The first one is to try to settle, and the second one you get your actual hearing. And he wound up paying essentially the same thing that he would have had to pay me, which wasn't a whole lot of money, but it made sense. In other words, he could pay them, get his truck back now. He could pay me, go through the process, and maybe not have to pay the state anything. Another one was a young man who was from Texas. He was pulled over for speeding, had Texas plates. This was in my community. No drugs. The drug dog didn't alert on his truck. He had a little over $30,000 cash on it. He had a prior drug conviction, and they seized the cash. Same result. I quote him a fee. He calls me back and he says, I can pay them the same amount of money and get all my money back. I said, well, that's a rational decision. And that's the decision that he made. Another case that happened recently in Obion County, and I've spoken to the officer that did this seizure. He had no information in advance on this 18-wheeler. Wasn't looking for anything in particular, but an 18-wheeler was doing 75 and 55. And so he simply pulls him over. And he asks him about his bill of lading, asks him where he had last loaded or unloaded, and where he was going. And the driver, he couldn't give really good information. Didn't know where he was going, said he wasn't carrying anything. Didn't know what he had unloaded. Anyway, he consented to a search, and in his search, there was $879,000 in cash wrapped in cellophane bundles in different parts of the cab of the truck. One was, a bunch of it was in a duffel bag in other areas. There was also a list of narcotics with weights and street names with the money, and he brought a drug dog that did work on the money. So, keeping it in my time frame, if you think about the first case, you know, if you're a property owner, it seems to me you should get notice. Not just of an opportunity to contest the seizure, but you should have notice and an opportunity to be heard at the hearing when the forfeiture warrant is obtained. That is a change that should be made. You shouldn't have to post a bond. You know, I do work for banks, and sometimes they'll want me to go and get an asset that's secured by a loan, and there's different ways you can do it. If you want, you can get immediate possession, but you have to post a bond. And you're posting a bond because, you know, you might be in the wrong. Maybe the loan was not in arrears, and maybe they should have the property back. But it seems to me the wrong person's posting a bond, particularly if it's cash money. Why in the world should you have to post a bond? They're holding cash. I don't understand that. It seems to me the bonding requirement should be done away with. The owner should be given an opportunity to testify. As you know, at these hearings on a forfeiture warrant, where there's no arrest, there is a notice of hearing that's given, but it's only to the person in possession. There's no requirement to give it to the owner of the property, and at the hearing, the only testimony can come from the officer and the person in possession. It seems to me the owner should be able to testify. For example, in the case of the young man that said he was there to buy hay, he said that's what he had. Well, he said he worked for a ranch. Well, I think his boss should be able to come in and say, yep, that's my 30 grand. I gave it to him. We do this a lot when it's parched in Texas. We send them cash because they don't, that's the easiest and best way to get it. Seems to me there should have been an opportunity for that. Same thing in the 18-wheeler case, where the owner of the trucking company had his truck stolen. So I don't think there should be a bond requirement. The biggest improvement to me, leave it in the courts. I have an aversion for administrative law. What is that? Who elected these people? I mean, I know my court, our judges are elected. You know, even in some cases in kind of a squirrely fashion that Tennessee elects judges. But at least they're there, and you leave it in the courts, because once that horse is out of the barn, or that snowball starts rolling down that hill, which is when that warrant is issued. Once that thing is issued, you know, good luck getting it back. But if you were in the courts, our court system, I think the due process rights would be greatly enhanced for the property owners. And then you go through the regular appellate process. You know, I mean, you imagine the looks I get and say, well, yeah, we can go and get a hearing. If you don't like the result, we get to appeal it in Davidson County Chancery. I'm way over here in, you know, the property was there. That's where it was. That's where it was seized. Let's have the hearing there. Okay.
Thank you.
My name is Ben Rabin. I do primarily criminal defense law. I've also done several forfeiture cases, and I think anybody that's done forfeiture cases has anecdotes, and I could give several of what I consider unfortunate and sometimes arbitrary decisions and results. But what I wanted to spend most of my time on was the Sprunger decision that I litigated in the Supreme Court. Just to explain kind of what happened, it was sort of an unusual situation because that particular offense, the seizure was for a child pornography crime. There's a specific statute that says if your property is used in the commission of a child pornography offense, they can seize the property used for that. And most forfeitures are for drug-related crimes and some other things, but it's the same general idea, and I think this case exposes a lot of the same issues. And so basically the case initially was investigated by the local sheriff's department, where they had a report that this man had been downloading child pornography. They did the investigation, they sent it to the local district attorney, and then they actually sent the case to the U.S. attorney for federal prosecution. There was an election, there was a new elected district attorney, and I later found out that the elected DA basically brought the case back because he wanted to be able to seize the property. So it actually, in this case, directly affected the charging decision from federal court back to state court because the state wanted to utilize this forfeiture proceeding. That could be concerning to perhaps the justice system for a number of reasons, not the least of which is that from a law and order standpoint, he actually would have gotten far more time in the federal system most likely than in the state system. So even though he had to deal with the forfeiture process, he actually got less time in prison because the DA decided that he wanted to take the case back. The sheriff in this case had never done a forfeiture before and admitted later in the subsequent proceeding that he was sort of uncomfortable with it, and basically had the DA give him the paperwork. And basically what happened is they gave Mr. Sprunger a notice. You have to give the person notice that their property has been taken. And that has a bunch of pre-printed items on it of how you can challenge the seizure to get your property back. And because, as far as I can tell, nobody had done that type of seizure before, it wasn't on the form, so they checked the other box, see attached. And of course there were no attachments. So there was no way that Mr. Sprunger could potentially challenge the seizure. And he even went to an attorney and said, what do I do? And he said, well, nothing you really can do, but the law says you're supposed to get a later notice from the Department of Safety. You have 30 days from that to challenge it. But then the sheriff and the DA never sent it to the Department of Safety, so it never triggered his 30 days to file the challenge. Meanwhile, they also put a lien on the house. They didn't eject him from the property, but they put a lien on it. So he couldn't mortgage it, he couldn't sell it, which was very important for him at the time because he was also indicted when the property was seized, and he couldn't use the funds from his house to hire an attorney, which I think is a tremendous, one of the lessons of this case is how that can affect people when there's also an arrest, that you lose your ability for those assets to potentially hire an attorney. In this case, his house, which was by far his most significant asset. And there was later a United States Supreme Court decision, Lewis versus the United States, in 2016, that said that could actually be a due process violation if you freeze untainted assets. Although that case had not been issued at the time, about 2009 when all this was going on. So the other problem that happened in this case is because he didn't know how to challenge it, he basically thought that he couldn't challenge it. And when he ended up being convicted on the criminal case and went to prison, he stopped paying his mortgage, and the house went into foreclosure. And from what I can tell, the bank basically sold the property at a fire sale, leaving all of $30,000 in the difference from what he owed, which from what I've seen from the numbers, it should have been sold for much higher, but he didn't know to challenge it, which he potentially could have done. And at the end of the day, as he continued to litigate the seizure case, it was not over the house, which was gone, but only the $30,000 balance from the sale. So he gets convicted, and then the district attorney moves to prosecute this forfeiture in court, which is normally a better way to do it, but is not at all what the law contemplates. And my client at that time wasn't my client. He didn't have an attorney. He actually had to represent himself, and he represented himself from prison and actually appeared at the hearing on the telephone from prison. It didn't go very well, as you might expect. He filed an appeal to the Court of Appeals. That didn't go very well, and he lost that also. And then he filed a petition to the Tennessee Supreme Court for his case to be heard, and they actually granted the appeal, and then they appointed me to represent him. So even though he had a lawyer at that point, it was an appointed situation because it's not a criminal case. I did it pro bono. They weren't allowed to pay me, and so I have no idea why I was selected other than I was a 29-year-old attorney that would do it for free. So that's often in the case, in the situation of appointed cases, the people who these people have to represent them when he finally did have an attorney. And we ended up prevailing in that case, and the Supreme Court overturned the forfeiture and created new law, and it's sort of now the preeminent case on forfeitures, and it basically says that you have to follow all these procedures in the statutes, and if you don't, then the whole case can be nullified, and you get your property back. But the problem is You still have to file the claim, you have to show all that, potentially litigate it in court to do that, which in his case, it took 7 years from start to finish. His property was encumbered and eventually sold. And certainly if it's a vehicle or anything else, who knows what condition that property will be in at the end. So he certainly was prejudiced significantly in that regard. As the story continues, there is, sort of the question is, well, what can you do? Okay, you win the case, you get your property back, what then? You're not entitled to any sort of damages, attorney's fees, or anything. There is a statute under Tennessee law for what they call a bad faith claim, which I have filed and is now actually pending in the Tennessee Court of Appeals. And even that relief is extremely limited. All you can get is the rental value of the property for the time it was seized, capped at the total value of the property. So the remedy, so it's unclear even with cash what that would mean. I mean, does cash have a rental value? And in this case, well, once the property was foreclosed, what happens then? And you also have to show bad faith, which is an extremely high standard. It does have definitions in the law, but it sort of has to, you generally have to show some sort of wrongdoing, which is extremely difficult. And of course, that requires a whole other lawsuit, potentially with an attorney who usually you'll need to find to work for free for the possibility of collecting later. So even if the property is clearly wrongfully seized, you may still not even have the chance at getting any sort of damages or recovery to even come out whole from the loss. You may not even be possibly eligible, but even if you are, you still have to get a court to agree. And in this case, the trial court said we weren't, because even though the Tennessee Supreme Court said that they had done it wrong, the judge says, well, I think they could have done it if they did it right, and that was good enough. So I'm currently asking the Court of Appeals to review that, and we're waiting decision, and hopefully we'll have a decision soon. But I think that, to me, that case, despite its unusual circumstances, illustrates a number of the problems that civil asset forfeiture has in Tennessee.
Thank you.
So I think I was asked to come speak here to address racial profiling and traffic stops specifically, but I want to kind of frame it out a little bit. So my basis of knowledge for that topic is strictly limited to Nashville, and I was part of a team that did a driving while black study. I pulled traffic stop databases from the police department. We analyzed those, doing data analysis, and it didn't take too long to hone in on the key issue being, is there discrimination in roadside searches? In other words, moving past the question of is there a stop disparity? What happens after the stop? Who's getting actually subjected to a search more often on the side of the road? And if you look at that question, what you found in Nashville, and you see this in other cities where studies have been conducted, there's virtually always significant discrimination in terms of who gets subjected to a roadside search. Talking about consent searches, which is where the officer doesn't have probable cause, but just asks, can I just search your car? And you find people almost always consenting because they feel some compulsion, from law enforcement, even though it's legally considered a consent search. But so in Nashville, we looked at all the different patrol zones of our police department here, which is divided up into about 50 zones, and in virtually every patrol zone, didn't matter high crime area, low crime area, mid crime area, there's always this race disparity in terms of who gets subjected to these consent searches. And mind you, these consent searches almost always fail. These are almost all innocent people. They are about 90% of the time not coming up with anything, about 9% of the time coming up with some kind of drugs, usually marijuana, and only about 1% of the time finding any kind of a weapon. And so where you have a search technique that doesn't succeed most of the time, and when it does, is usually finding just some kind of personal use marijuana. And then you see, from one patrol zone to the next, usually 200 to 300% disparities between, our black people being searched more frequently than white people as a proportion of stops. And we had one patrol zone where it got all the way up to over 1,000% disparity. And then also found that the hit rate, the success rate against black drivers was actually lower in almost every patrol zone than against white drivers. And so you're kind of looking at this issue in the context of civil forfeiture, you start to see civil forfeiture as essentially almost an intentional de facto tax on communities of color, where that's who's being targeted by the war on drugs, whether that's due to policy or practice, or whether it's due to implicit bias, or whatever the cause of that is. We see that. We saw it in Nashville year after year. We see it in communities all over the United States. Everywhere it's been studied. And you have to recognize that if civil forfeiture is just taking stuff from people after these traffic stops, that at that point is really a tax on communities of color. I also, just framing this out in kind of a big picture, I think it's important to recognize that there are many, many voices in the world that have for decades been saying, like The Economist magazine, this whole war on drugs enterprise is actually just increasing murders and robberies, and it just creates crime. And so to the extent that civil forfeiture represents basically a scheme to pay law enforcement to focus on that drug prohibition effort, that could be looked at as basically we're increasing murders and robberies and crime by creating incentives to be engaged in drug cartels. And of course, that's done by creating black markets that create a market. In other words, if Walgreens could sell marijuana, you would not have drug gangs, you would not have drug cartels. That wouldn't be a business for them. And so, to the extent that many of the robberies and murders that happen are related to drug cartels or small-time gangs that are engaged in the drug trade, that sustain themselves through the drug trade, there's a case to be made that all that crime is happening essentially because of drug prohibition. Of course, we saw that with alcohol prohibition. The 20th era kind of knows that component of that. And so, taking those two pieces and then thinking about a third piece. So we've got documented race discrimination. We've got this drug prohibition that creates crime essentially. And then looking at criminology studies that have indicated that when you have particular communities that feel alienated by law enforcement or that feel alienated by the system, then members of those communities start to think, well, I don't feel like I can reach out to law enforcement when I'm feeling unsafe. I have to handle my safety on my own. And that's where things start to really get dangerous, because if I have to handle my safety on my own, that means I need to start using kind of an honor strategy of deterring others by appearing dangerous and sometimes engaging in violent acts. I have to respond to disrespect with violence. And so now, not only are we adding to crime and violence and murders through the sustaining and creation of these gangs, through the race discrimination that's part of the system, we are alienating communities, which then results in more violence in those communities because people are afraid of the police. And so they're going to handle it themselves. And so I think, this goes beyond forfeiture, but when we're talking about forfeiture, again, I mean, it's plain and simple. It's just a way for the police to get paid to focus on this particular type of law enforcement. It's an incentive to not focus on other types of law enforcement that would likely be better for community safety. And finally, I want to address the topic of citizen misconduct complaints and disciplinary review of those complaints. And if you look at those systems that are in place in most law enforcement agencies, when a citizen files a complaint, say like a Fourth Amendment violation in a search, that results in forfeiture, what they look at, with the supervisory staff and the internal affairs, what they're looking for is there some sort of hard evidence to prove this citizen's complaint? Is there like a video that proves they're correct? And if there is no hard evidence to prove that the citizen's complaint is correct, then that complaint is not going to be sustained. Okay, and so that being the system, many jurisdictions, including this one, don't have video cameras, at least not yet. And so you don't have a way for a citizen to really make out a complaint that's going to be sustained, unless somebody happens to have a cell phone recording or something. But also, one of the classic ways that officers justify probable cause search of a car is to say that there's an odor of marijuana. Well, then how does a video prove that there was no odor of marijuana? It can't. And there's no way a citizen can ever produce hard evidence that there was no odor of marijuana. Even if nothing is found, as long as the officer tells his superiors, well, I smelled it, and I don't know, they must have smoked it. That's it. Will not be disciplined. And so, again, along with financial incentives of these departments are making from getting these calls, now we have no way to hold officers accountable, and thus we really have an incentive to violate people's Fourth Amendment rights and then to just commit perjury to cover it up.
Thank you.
Good afternoon. My name is Joy Radice. I'm an associate professor at the University of Tennessee, and I'm going to try to shift our gears a little bit, but not a lot, and talk a little bit about what I see as the potential for actual constitutional challenges, and then move to some of the practical problems with the procedure of civil forfeiture. I mean, it's been fascinating to take a look at civil forfeiture. My research focuses normally on things that impact people with criminal convictions that extend beyond their conviction and their punishment is over. And so civil forfeiture in some ways kind of flips that on its head, especially when we're talking about individuals who are never charged with a crime. It actually says, is there punishment for something where there's actually no proof or evidence that a crime is even committed. And so this has been kind of an interesting new area for me to get into and thinking about coming to present to you, because that is somewhat unusual to actually take something, and it does seem to implicate as a result the due process clause. But I'm going to take a step back and say that scholars have been looking at this issue, legal scholars, for 3 decades and critiquing it and saying that the actual law on the books and the actual Supreme Court jurisprudence around this doesn't entirely make sense. But the biggest problem is that it's not a new problem, right? Some of the scholars date back civil forfeiture to Exodus in the Bible. Some of them look at piracy, the attempts of England to take away assets from pirates when they couldn't convict them. And so when you take a look at Supreme Court jurisprudence from the early 1800s, you are seeing the permission to do that. And so when we're thinking about what are potential constitutional challenges, the thing that we run up against, I think, in terms of a valid and a successful due process claim is there good? No worries. It's okay. In terms of thinking about a valid due process claim, is that the Supreme Court, in terms of due process and in thinking about it in terms of due process, has predominantly thought of it as civil. And the Supreme Court case in Sprunger reiterates that repeatedly throughout the decision, the Tennessee Supreme Court case. So in thinking about whether or not there could be really valid due process challenges in Tennessee, you have to look at the process on the books. And that's problematic. Caleb Nelson, a professor at the University of Virginia, wrote an article in the Yale Law Journal in 2016 that basically said, these laws are problematic in practice. But when you take a look at how they're structured, they usually meet the technical Matthew v. Eldridge requirements. And that's super problematic for us, because unless you can go to how the process works, which is what was nice about Sprunger, and I'm glad that Ben had a chance to talk in such depth and in such a personal experience about it, because what you saw the Tennessee Supreme Court do there was a little bit different. What the Tennessee Supreme Court did in 2015 in his case was say that, okay, maybe on the books it looks like it meets due process and Matthew v. Eldridge requirements, but in terms of the practice, there has to be both procedural and substantive provisions that align with the Tennessee Code. So what they're actually doing has to be what they say they're doing. And I think that that was a really powerful part of that opinion, that is what people and defense attorneys and capital attorneys that I've talked to have been latching onto. And I think that we're going to see a number of cases coming up the pike that actually are looking at whether or not that we can extend Sprunger to similar cases, especially innocent owner cases. But the due process challenge is, I think, the most obvious challenge, and so I want to shift gears from that and talk a little bit about the Eighth Amendment. Most of the time we think of the Eighth Amendment, we think of cruel and unusual punishment, but I think that the most instructive case I could find for you in terms of this was a Pennsylvania Supreme Court in 2015 that basically said, we're going to use the excessive fines piece of the Eighth Amendment to take a look at an innocent owner. And that was really interesting because in 1993, the United States Supreme Court gave us 2 cases that opened the door for that. And I think that in terms of thinking about constitutional challenges, excessive fees is probably the area we may get the most traction in looking at challenges to the Tennessee statute. In specifically, United States v. James Daniel Good Real Property, in 1993. Justice Thomas, who was at the time was actually writing a concurrence and also dissenting in part, gave us insight into, I think, what we're seeing now when we're taking a look at whether in practice these laws are really giving people, or really punishing people. He said, given that the current practice under the law appears to be far removed from the legal fiction upon which the civil forfeiture doctrine is based, it may be necessary, and even in an appropriate case, to reevaluate our general, this is the general deferential approach of the Supreme Court to legislative judgments in the area of civil forfeiture. So the Supreme Court, starting in the 90s, recognized, whoa, what's actually happening on the ground is different than what we hoped would happen in the area of civil forfeiture. And so it's looking more and more like punishment. And they actually use the punishment language. And so in terms of thinking about what types of challenges might get traction, in terms of thinking about challenging the Tennessee statute, I think the Eighth Amendment has fertile ground for us. I was glad that Kyle talked a little bit about disparities, because that's another area that scholars look to in terms of disparate treatment, whether or not we can actually show some type of disparate impact or disparate treatment, any type of discriminatory effect based on a statute. But based on the research that I was looking at, it makes it really hard, based on the little evidence that we have and the little data that we collect specifically about forfeitures, to go from the stop, the search, and the discrimination happening along the side of the highway to the actual forfeitures that are happening. And so although we have a sense based on these studies about racial impact and disparity, I don't see the data that would be necessary to actually put forward a very strong disparate impact claim for forfeiture. And I'm curious to see if Kyle has more thoughts about that. And that's really troubling, actually. And it was interesting to me, and it was surely helpful that in 2016 and 2017, the Tennessee legislature is now beginning to collect, or requiring the collection of more robust data around this. But it was troubling to me that one of the categories being collected was not identifying characteristics of the individuals being stopped, to make that claim, to make a more disparate or any kind of discrimination claim possible. So those are the three major areas that I could see in terms of constitutional claims that the committee may want to take a real look at and determining whether or not there is fertile ground for any type of challenge. But because each one of them is fraught with problems, I think then we have to look at the legislature the same way is happening in legislatures throughout the country as the real place for the solution. And so in thinking more about that, I hope we're able to talk about ways in which the legislature can do that. Thank you.
I would please defer to Mr. Osborne, if you would please.
Thank you.
Well, you're very nice. I'm sorry for being late. We have just been slammed at the office today with emergencies. Plus, I wandered around the garage here for 15 minutes trying to find a sign that told me how to get to the library entrance. Without further ado, those of you who know me know that I'm a man that's very blunt, and I came here today prepared to be extremely blunt with this committee and the commission. I'm here today to speak really in reference to how civil asset forfeiture affects the foreign-born and the immigrants on the highways. This is what I'm about, and that's what I want to address myself to. The ACLU reports that in some areas, 2/3 of the assets that are seized in these programs are from minorities. And what we're doing is we're seeing a divestiture from minorities, as little money as they have, over to drug task forces, and the use of the money that's, in my view, in many ways being squandered. Why? Because there's no oversight. No oversight at all over the expenditure of this money or in the conduct of the officers that engage in these forfeitures. Cash and property seizures, this is not a partisan issue. Cash and property seizures under President Obama's administration exceeded $3 billion. Most of that coming from poor people, minorities. Under the program, under Obama's program, local agencies could still retain up to 80% of the proceeds. However, Attorney General Holder did implement some limitations on it. It was limited to illegal firearms, ammunition, explosives, and child pornography. That's what you could seize proceeds from. Now, as we'll see in a moment, General Sessions has reversed all of those limitations. Katie, bar the door. And I predict that that's going to lead to an immense problem with due process and with abuse of what would otherwise be a very commendable program, and that is to stop drug trafficking. Now, state law in Tennessee provides very few procedural safeguards. Tennessee legislature has utterly failed to be a watchdog in this area. They should be ashamed of themselves. I don't know why they even come to Nashville, because they haven't been helping the poor and the people that need their protection the most. No one has to be convicted or even charged with a crime in order to have their assets, their money, taken by the Drug Task Force. Here's what happened in Tennessee in 2016. I don't know, since I'm late, I don't know whether this has been covered or not, but I'm going to tell you what I've learned. In Tennessee in 2016, 7,616 civil asset forfeiture proceedings took place. Last year alone, $17 million were taken in these asset forfeitures in 2016 alone, mostly from poor people, a lot of it from immigrants. And they sold or seized 3,636 vehicles. The most active task force in this area is the 21st Judicial Drug Task Force out of Franklin, Tennessee. How do I know about it? Because I travel to immigration court all the time on I-40 West from Nashville to Memphis. And every time I go, no matter what the time of the day is, I see 2 or 3 black SUVs parked in the median. I know who they are. They never bother me because I'm wearing a shirt and tie. But they did bother one of my colleagues one time. His name is Sean Lewis, an immigration attorney. He doesn't look at all like me. He has long hair because he performs in a band on the weekends. He has fun on the weekends instead of doing what I do, married to a computer all day long. And guess what? They stopped him, and they stopped the wrong guy that time. I won't go into the details of what happened, but he doesn't have any more problems out of them anymore. But most people don't know what an attorney knows to deal with these people. Now let me tell you what the impact is on immigrants and why I'm here, and I don't know when I started, and I know I have 8 minutes.
You have 2 minutes and 22 seconds remaining.
I have 3 minutes, 22 seconds. Okay, very good. I wonder what that little card was. Okay, well, I'm going to make it quick. Here's why this impacts immigrants so badly. First of all, language barriers. Many of them are on their way to immigration court in Memphis, and they don't speak English very well at all. And so when they're stopped, the language barrier is an important consideration in that stop. They have no knowledge of their right to refuse to answer any questions. I do, but they don't. They don't have an attorney with them. They have no knowledge of their right to refuse a search. I would tell them, go away. You don't have any right to search my car. Who do you think you are? Intimidation, my immigrant clients are intimidated by the appearance of those vehicles. Those big black SUVs look like something out of the criminal underworld. and then they turn on those blue lights, and that just scares my immigrants to death. They're already scared of police anyway, because most of them have been targeted by police in the communities which they come from. Not true in Nashville, but it's true everywhere else in this state. They're intimidated by the appearance of weapons. They come up there with those big guns and those big holsters. And of course, they make it their business to make those guns and holsters very visible. The aggressive manner of the interrogation. They also carry large amounts of cash. Why? Because they can't open a bank account. Why? Because they have no Social Security number. They also have no driver's license. They pay me in cash a lot of times. My bank called me a couple of years ago and said, Mr. Oswald, why do you handle so much cash? I'll tell you why. I told them, I said, because you don't allow my clients to open up a bank account in your bank. That's why. And so when they go riding down the road, all they have is cash. Travel patterns.
Can you just wrap up?
Yes, I'll be glad to. Travel patterns, appearance of nervousness, that's an indicator of guilt. But my immigrant clients are always nervous when they encounter police. Fear of going to court, and until recently, limited court access to Chancery Court of Davidson County. You had to come all the way to Davidson County to contest this. Well, I have some changes I would recommend, but I'll just hold on to those. Thank you very much.
Thank you.
I'm Frank Lamb. I'm not maybe one-time appropriate person to have here. I'm a very much rubber meets the road guy. I represent all the people to get their stuff back. And if you want to know how to get your stuff back and the problems that's so unfair about this process, I'm the guy to talk to. Okay? So here, I would like to lay out what you have to walk through when somebody from the government takes your stuff. Okay? I want to put that on the backdrop of what we look at as our criminal justice system, just to give you a background, because it's pretty good. We have a pretty good criminal justice system. We have a clerk. There's a clerk of the court of every county in the state of Tennessee, and they file your papers. And the state legislature tells them what to charge, and then they file the papers for them. There's an independent judge, and then an appellate judge, who are elected or appointed by whatever process we have. Then we have a prosecutor's office who charges crimes basically and prosecutes them. And that's a pretty good system. Now I lay that out to give you the backdrop of what happens when they take your stuff. So they show up at your house and they've gone to the trouble of getting a search warrant. They've had to convince a judge somewhere that they had some reason to come into your home. That makes sense, right? To get a search warrant. But when they get to your home, they are allowed to take everything you own without a search warrant. First problem, right? The last case I had, when they took all of the electronics and all the little Game Boys, you know, that the children play, the PS4s and things, they take all of those, they take all of the cars, they take all of the money, and they busted, is that a word? The piggy bank, and took $147 out of the piggy bank. There were two children in the home, without a warrant. So they take all of your stuff. They take all of the cars. You have no car, you have no money, and they attach the seizure to the bank accounts that the individuals have. No rent money, no electric bill money, no anything. That's where the process starts. But they do hand you a green piece of paper that says, here's why we're taking your property. Check, narcotics. That's it. You don't get, you sold narcotics last week, you sold narcotics today, we think you're moving heroin. You get a green piece of paper, and that's how I always know my clients about their property taken. They have a green piece of paper in their hand. And it has a box check that says narcotics. So they come to me, and I tell them they have a right to petition to get their stuff back. Now, sir, if you want to take my stuff, and let's say you, I think you're in the printing business or the news business, and I didn't pay my bill, and you want to take my money, do you pay to file a lawsuit to get my money back? You would, wouldn't you? Yeah, right? You have to pay, and then if you win, you get my stuff. Not so in forfeiture. The people who had their piggy bank busted, they have to pay for the privilege of asking the government why the government took their stuff. You know, I talked about the independent clerk before. Well, it's $350 to ask to get your stuff back, kind of. See, we don't have an independent clerk in a seizure case. My opponent, the prosecutor, which is appropriate, of the forfeiture, someone has to do that, represent the state side, is also the clerk of the court. They decide if my filing is on time. They also get to pass the rules that say how many $350 you have to pay. We took 3 cars from your client, Mr. Lanham, and we took them on 3 different days, so you have to pay 3 times $350. Now, this isn't a judge making this decision or a clerk of the court. This is my opponent who decides how much money I must pay to ask my clients, to ask the government why they took my client's money. But eventually we get that done, right? So, and there is an administrative judge, the fairest part of this whole process. We have a pool in Tennessee of administrative judges. They get called upon to hear these cases. Sounds like a wonderful idea. I really like it. And we get to have depositions. Really helpful. I take a lot of depositions in seizure cases. And we send a notice of deposition because we have a right to, we want to promptly get our stuff back, right? Well, if we ask for a deposition and the judge says I get to take it, my opponent, the Department of Homeland Security, can appeal to the administrative, the appellate position of Homeland Security, their co-workers, and they can stop the deposition from happening. By rule. Guess who wrote the rule? The Department of Homeland Security. My opponent writes the rules that stops the process that prevents me from taking the deposition. But eventually I may get through that part of the process, and we've got a statute that says we get a hearing within 30 days. Well, you don't really get a hearing within 30 days. You get told when your hearing will be within 30 days, and it may be 6 months. So we go to the hearing, and occasionally I put on the proof, and this administrative judge says, "You're correct, Mr. Lanham. Your 2 clients who are Jehovah's Witnesses who've never seen a drug in their life, whose son worked for them and got caught with drugs, after 9 months should get their cars back." Thank you, Judge. My opponent in this case can then appeal. Would anyone speculate who they appeal to? Anyone, please guess. Her boss, the commissioner of the Homeland Security. And he can override the administrative judge. She literally appeals to her superior. That is an unfair process for anyone to labor under. And what happens is, the boss then can make a ruling of whether or not the administrative judge was correct or incorrect. And many people, this may involve $1,000. They love to take $1,000, by the way. Nobody fights back. They love to take $3,000 because nobody fights back. And there's a rule, and I couldn't find it this morning, and Mr. Raver or someone can help me, but there was a rule, at least last year there was, that said if the commissioner decides a rule of law and no one appeals to the Chancery Court of Davidson County, that is now law binding on all of the administrative judges. So my opponent's boss now is writing the law that is binding on the one independent person who is involved in the process. Everything that happens in this seizure process is reviewable by my opponent. My opponent's office gets to decide if I filed on time, if my client is indigent. Can you imagine if your opponent got to decide if your filing was good? Every single seizure goes through this process. Last thing, but you think you can appeal to Davidson County Chancery Court. And I won't bore you with the law, but did you know the Chancery Court doesn't get to decide if they think the seizure was right or not? They do not. It is a review of an administrative decision. If there was any evidence to support the decision, even if the chancellor disagrees, he has to authorize and support the decision. Yeah, that's what I said. I said that's another word, but I won't repeat that today. That's what happens in reality and people pay. I'm gonna say one last thing, if there's 1 minute. I had a 90-year-old client ask for his truck back. And I called the audience, I said, it belongs to a 90-year-old man, his grandson was driving, you found marijuana. And he said, well, tell the 90-year-old man if he don't want to wait for 120 days for his hearing, he better pay me my $500. He paid $500. He needed his truck. That's where the rubber meets the road. Thank you so much for having me.
Thank you.
When you mentioned some of the federal constitutional issues, have you looked at any potential state constitutional challenges to this? There's the no civil fine over $50 and a few extra provisions that would be in the U.S. Constitution.
I was specifically focusing on the federal ones.
Daniel Horowitz.
So we've had several panelists speak here this morning. Law enforcement made clear from their perspective that civil forfeiture is an important tool for fighting crime, and suggested that based on recent reforms, perverse incentives or potential for misconduct had largely been eliminated. There were some other panelists from reform organizations that suggested that there were some systemic incentives built into this practice that undermine the entire concept of civil forfeiture in practice. My question is, in your experience with forfeiture cases, roughly what percentage of them do you think are influenced by a profit motive or a monetary incentive rather than for crime-fighting purposes?
Was that addressed open?
Dave
May I?
May went on the panel.
I'll go back a few years because the statute of limitations is run on what I did that day. I had a truck driver who was stopped and he had $18,000 in cash on him. And I showed up at the seizure hearing, and my opponent has written a rule that says you don't get a hearing the first time if they want a continuance. It's just a rule. They made it up. And so I go, and these 4 men come rushing in, and they are just wild. And they said, we're going to have a hearing today. I said, no, no, no. I think everybody gets intense. We're going to have a hearing today. And I said, no, no, no. And finally, everything calmed down. I asked a gentleman named Orville Orr, a great man who worked for the Department of Safety. He was a good guy. And I said, what's going on? He said, I'll go find out. He come back. 3 of the men were from the Obion County Drug Task Force. The 4th was someone they wanted to hire. The $18,000 was funding his position. They got their prosecutor on the phone and came to me and said, if you will give us the $18,000, your client will never go to jail. We gave him the $18,000, and he never went to jail. Profit, incentive, jobs for friends. I did that, and it was legal. I hope. Does that answer your question? There's a little profit motive in it. They don't carry it home, but they get to buy the cars and the guns and hire their friends. And they're weightlifting machines.
Sigrid Franklin. Elliot.
Yeah, just a general question. You know, how come the police are undercovers the cars, and then intimidate the people, even when they stop some of immigrants, they have their kids in the cars, and they intimidate them. How come nobody does anything, not even the city or the chief or whoever, or the police department, or just this things here that happen a lot.
Well, it happens all the time. And it's because there's no oversight. Basically, there is no oversight. Zero. If you want to try to reverse this, the first thing you want to try and do is to reverse Jeff Sessions' reversal of the Obama administration limits on civil asset forfeiture. They were very modest, but even that got changed by Jeffrey Sessions. I want to make a remark here on the record, and it's not meant to be partisan. But it's ironic to me that Jeff Sessions thinks today so little of a person's property, when his great-grandfather, I did a little bit of research, Jonathan James Sessions died at Antietam in Sparksburg, Maryland, for what he perceived to be the property rights of slave owners to hold on to their property, their slaves, without any government interference. And he died for that cause. I think it's shameful that we have come to this point in American history where we don't recognize the property rights of people when 150 years ago we recognized the property rights of slavery as property. It's ridiculous.
Next question, Seiko. Franklin?
I have two questions, but I'll reserve the second one if we have more time. It's just a quick question. The constitutional remedies, 14th Amendment, have you seen that being used potentially as a constitutional remedy?
So that, I think the 14th Amendment has similar problems with as the disparate, like an actual evidentiary showing, because you still need some degree to which you can actually show there's discrimination. And so that's why I think that the focus has been more on excessive fines, even more so than due process in terms of where folks are going. But it is based on what we know from the ground. It is an important challenge to raise. I'm not certain how successful it would be.
It's a tough standard, right? You have to be able to show that the municipality is deliberately indifferent to the fact that race discrimination is going on. So, yeah, go ahead.
Can I just add a follow-up? I know that in some, the legislative folks were here earlier, and some of them hinted at least a disparate impact based on poverty. And I'm wondering if in the committee hearings, if they talk about disparate impact on race and poverty, could those committee hearings around the civil asset forfeiture law be used then to bring a disparate impact claim around the 14th Amendment, especially if they went on the record arguing that there is a disparate impact claim in a state legislative committee hearing or Senate hearings? What do you guys think about that?
Well, certainly, my thinking on this is that if you make a municipality aware of its practices and what's going on, and then it doesn't do anything to change its practices, then at that point it has become deliberately indifferent. And so you can kind of build a case by creating awareness. Certainly a committee hearing can serve that purpose.
And in terms of a case, for race you have strict scrutiny, right? So you have like the most powerful way to show or wait on the state to not act in a certain way. Class hasn't been granted that level of scrutiny. And so to show a rational basis is all they would require, and that's such a low threshold.
Okay, a question,
Yeah.
Brian Crum.
Are you familiar with any 1983 actions in this area at all? I mean, that seems like a remedy that would be available to...
There's a national lawyer who has a 1983 lawsuit right now coming up in federal court. So yes, so I think there are actually a lot of things percolating right now. And so the legislative fix is the fastest in my mind because the litigation just takes a really long. I mean, the Sprint case is a great example. I mean, how many years later? And so if we want to solve the problem now, I think the legislature is the way. But if not, these cases are going to move up to district court, to appellate court, and then ultimately the Sixth Circuit.
Okay. I have a quick question. Most of you are practitioners. This morning, it was our law enforcement panel that made it clear that having cash is not illegal. Although Attorney Miles noted a client that had cash and a prior, and the property was to the cash receipts, the $30,000 was seized. Is it your experience that when cash is found, when there's a stop and there's cash, they'll run a prior, and if they find a prior, that becomes that sufficient probable cause to actually seize that cash because of the existence of a prior, which goes to your original focus, which is on the rights of folks once they criminal.
Well, I think we need to correct a misunderstanding here. There is no need to prove probable cause in order to seize cash.
The law, the officer has to have a belief that is
But
subject.
not probable
No,
cause.
I understand. They were using that term this morning because when you then get to your warrant hearing, you have to show probable cause at that point. In your experience?
I've had that experience. I had a client who I had brought the brief with me, I filed here. He had $15,000, he mowed lawns and had several different kinds of businesses. Took $15,000 away from it, and all they found was some crumbs of marijuana, which would not be grounds for seizing anyone's property. We fought that, and it was returned to him via a check from the Wilson County Sheriff's Department. We won. They then raided the home he was at, and once again found no drugs, and took $15,000. The commissioner, they make us prove that it's my client's money and it's not drug money. My first exhibit was the check from the Wilson County Sheriff's Department. That's where we got it. The judge ruled in our favor, and the commissioner, who is my opponent's boss, overruled the administrative judge that we had not shown that it was valid money. Both instances, no drugs to substantiate the seizure were taken, and once the literal check was from the Sheriff's Department where the cash came from. Cash alone is what drives forfeiture. They need the money to justify and fund the existence. If there's cash, and you don't take the time to bow and explain, you will lose it. But guess what? You get to call me and file a claim in front of the commissioner.
Can I only add one quick thing, which is that I feel like because we have lawyers on this panel, one thing that we've been remiss not to talk about, so I hope it was talked about earlier, is that most of the folks, because it's such small amounts of money, $1,000 to $5,000, don't have counsel. And that in and of itself is we can have like a whole day conversation about that.
Or $350.
Yes, Daniel,
Quick follow-up on that. Roughly, in your estimation, this is for Mr. Lamb, Mr. Raven, and Mr. Miles, in order to challenge a forfeiture, or to pursue a forfeiture claim from its inception to its conclusion, if you were billing hourly, roughly how much would that cost?
I represent two members of the Jehovah's Witness Church who've never seen a drug because their son had their car. And I charged a $7,500 fee, and I lost money. It was not a profitable enterprise. It was a 3-day hearing that took about a year and a half. That wouldn't touch, so I lost money. It's $7,500.
Let me answer this way. When somebody comes to see me, I want the best result for them, right? And I mentioned earlier that I assume that rational people are going to make rational decisions. And so if I take them and tell them what I'm probably going to charge, and if it's a weak case, I can usually get their property back, but they'll have to get some, blood. They'll have to give up a little something. But, the rational person, rather than pay me potentially, in my case, either go to Dyersburg twice or to Memphis twice, and then if you don't like the result there, go through the so-called appellate process, which attorneys are right, the opportunity for review is very limited. Most of them are going to go back and instead of hiring me and paying me $4,000, $5,000, $6,000, $7,000 and say, look, will you take $3,000 on this weak case? And generally, in my experience, that's what happened. I'm trying to get the best result for my client. Pay me $7,000 or pay them $3,000 and get his property back. That's frankly the better result. And that's why I said the answer, it was spin around all this. The answer to me, get rid of this administrative court situation. Leave it in the courts. If you get the forfeiture warrant in General Sessions Court, then that's where the case is. And you can proceed from there to circuit, or if it starts in circuit, you can just go on up the line there, and then give everybody notice, including the property. Give them notice, and let them come in there, and let, in my case, the guy, if he was a ranch hand, let his boss come in and say, yeah, I gave him $30,000 cash. That's my money. Here's where my ranch is in Texas. We feed so many cattle, we're in a drought.
I guess what I'm trying to figure out here is whether it ever makes fiscal sense for somebody to challenge, say, a $500 forfeiture or a $1,200.
Never.
No.
Never.
Have you been up to 5,000?
Never.
8,000?
But it would get cheaper if you would leave it in the courts.
I may be in the criminal case anyway, and if it were in the same courtroom, the same county, I would. that it's a separate county, a separate court proceeding altogether. I'm sorry, I was trying to answer that.
My question is just, if an undocumented, carries a lot of money, a lot of cash, and gets stopped, and all of a sudden, does the police keep the money, or what they do? They return it to the undocumented after they deport?
Well, they turn it into the drug task force, who has their own little kitty, and they pay for their own little pet expenses. One of the reforms that needs to be made is, at the very least, turn this money over to the general fund. Stop putting it in these drug task forces.
All right. Thank you. Thank you all for your testimony today. We appreciate the information and your attendance here. So thank you all very much.